Good afternoon. Please consider this short video in line with an article on the issue of child custody. Of course, the child is sometimes termed as the solicitor's invisible client because most issues where a marriage breaks down relate to the welfare of the child, and sometimes children are used as a bargaining counter to achieve a settlement. It is unfair, but that is a fact. Where the parties are at loggerheads, children are sometimes used as pawns in that scenario. The law as it was some years ago referred to two nouns, access and custody, insofar as matters relating to the children were concerned. So access was how often, for example, an absent parent would see the child, and custody was with whom basically the child lived and who had care and control of the child. Matters concerning the child's welfare were dealt with in custody orders, for example. But the law progressed, and then the terminology was changed, and one then referred to contact and residence. Contact was how often the child had contact with the absent parent, and residence was with whom the child lived. But matters moved on thereafter, and then the changing terminology was reflected in child arrangements orders. Child arrangement orders are such orders that deal with exactly what it says: child arrangements, with whom the child will live insofar as contact is concerned, and how often the absent parent would see the child, holidays, weekends, so on and so forth. But with child arrangement orders went parental responsibility orders. So the child arrangement orders would set out matters relating to the child, with whom the child would live, and how often a child would see the absent parent. And parental responsibility orders also went in hand, because the person with whom the child lives would have parental responsibility, usually. And parental responsibility should, in actual fact, be joint responsibility, so that both parents have responsibility over matters concerning the child, concerning the child's welfare. Sometimes it doesn't work like that. Sometimes it's considered that one parent is not fit enough to have parental responsibility. But a child arrangement order will not deny a father or a mother to see the child, but it may be that one party is more appropriate, insofar as the court is concerned, to have parental responsibility. Matters only go to court if really necessary, and the court will only make orders if necessary. And it is always in the interest of the children and the parties that matters are dealt with by way of agreement and a consent order is obtained. And in an ideal world, one would have a child arrangement order whereby the child would see the absent parent during weekdays or weekends and holidays, but live with the other parent. So that would be the child arrangement order. And parental responsibility would be that both parents would have responsibility over the welfare and well-being of the child, their education, their upbringing, the sort of schools that they should go to, so on and so forth. That is, in a nutshell, what the terminology means to date, how it's evolved up until now. But the most important aspect of this talk is to always consider the child's best interest as being paramount. That is enshrined in our law insofar as matrimonial law is concerned. Also, in other areas of law, it is a paramount consideration. Thank you.